Alright, Chapter 11, Part 225, Railroad Accident Incident Reports and Classification Investigations. Alright. Chapter 11, Part 225, Railroad Accident Incident Reports, Classification, and Investigations. Generally, on a regular basis, inspectors should contact the periodically inspection of each of the railroad accident incident reports, determine the compliance with the FAA Railroad Accident Reporting Rule. Each inspector should make the thorough, careful examination of the records of priority for each of the railroad in their territory. Inspectors should also review, analyze accidents, incident reports during the accident investigation as directed in Chapter 4 of the General Manual. Inspectors should review the Part 225 of the records of the reports, including accountable accidents, incident report records, to ensure that each of the record in the territory correctly recording the accident incidents when appropriate is correctly reporting accident incident. The FRA, when inspectors determine that an accident or incident shall have been reported to the FRA, the inspector should verify the railroad reported the accident incident above the reported it correctly. When conducting a system review of the railroad accident incident reports, and an inspector should contact the railroad's reporting officer to answer the question about the FRA regarding regulations arranging access to the records maintained with the reporting officer. Irregularities formed during an inspection of accident incident records must be brought to the attention of the reporting officer. Corrective action. Guidance. Inspectors should cross-reference other available materials to ensure the railroad correctly reports accidents in compliance with Part 225. This can be accomplished by taking in the part information about the accidents and incidents provided with the discussion between the inspector reported railroad employees officials, in addition with the claims of the records outside the documents, and comparing with the information with reported with the correlation of the FRA forms. The discrepancy between the provided with the verbally to the inspector by the train crews, track records, mechanical employees, railroad managers, and any other knowledgeable person, and the actual facts reported by the FRA forms should be investigated in a timely and professional manner. The FRA policy for the railroads of reporting grade crossing accident. In mid-2004, the Federal Railroad Administration, acting association administrator for safety, issued a verbal instruction for each of the clear-out, cut-out violation of the accident incident reporting obligation should be absent special circumstances and be subject to the proposed civil penalties in case of the failure to report highway rail grade crossing accident report accidents or incidences. Those verbal inspections noted with the use of the civil penalty authority and subject to the general guidance and containing the Title 49 CFR Federal Regulation CFR Part 209 Appendix A, which specifies the criteria to be applied when making the determinations. Appendix C, which addresses the Small Entity the Regularity of Flexibility Act, the Small Business Regularity Enforcement Act of the SBREFA, Small Business Regulatory Enforcement Act. So, for example, the FRA inspector encounters the signalman mistaken the failure of the small railroad to report the grade crossing collision, e.g. out of the confusion of the monetary threshold record of the railway equipment accident incident, and if the railroad immediately files as reported as required, the FRA might refrain from using the civil penalty out of the deference of the congressional policy related to the small entities and recognition of the fact that the circumstances are also repeated. Accident incident reports is so fundamental to the system of the railroad safety oversight program development. Strong emphasis enforcement warranted with the non-compliance with the detected. Inspectors are required to submit the violation reports for each defective detected violation of Title 49 CFR Part 225 when the violation is questioned. The clear cut of the failure to report the highway rail grade crossing accident incident involving any of the questions without regarding the interpretation of the regulation sufficiency and the accident constituting alleged failure, subject to the application of the Small Business Regulatory Enforcement Act, the Public Law Number 104/121, which were relevant. The FRA has the right to cite the railroad for each of the day of the violation and continue this can represent a potential highly liability. Each highway railway grade crossing accident incident non-timely reported. The FRA will usually use this mechanism, citing it for multiple days, to assess the more substantial penalties while the railroad conduct consistent with substantial justification. Accident incident reporting fundamental of the system railroad safety oversight of the program development. Strong emphasis enforcement warranty with non-compliance detected. Inspectors should reference Chapter 3 of the General Manual. Regulatory non-compliance required recommendations for the penalties and for more information. Reference material. In addition to the operating practices compliance manual, there are several other sources available for the additional information guidance relating to Part 225, including the technical bulletins, guidance memos, response letters. Inspectors should reference these materials to assist the conducting system with wide reviews and prior to taking the enforcement measures. The following list is some of the key guidance documents currently available. However, the lists are addressed of the more materials publicly available. The FRA Guide for Preparing Accident Incident Reports of Accident Incident Forms AR Guide. The FRA complying with the guidance of the Submitting Accident Incident Reports of the Alternative Method Companion Guide. Guidance letters. The FRA routinely provides railroads with written verbal guidance with the variety of issuing relating to Part 225. The FRA invasions of making the guidance more widely available. If it will help improve the FRA's enforcement process of accident incident reporting, the FRA will start posting certain approved with written guidance for response letters to the railroad in response to the FRA's website. Technical training materials. Please check with the operating practice training specialist to obtain the relevant update in the training materials. These materials will include the operating practice compliance manual as in routinely updated. Below is an additional guidance with respect to certain parts of the 225 Public Law 103, 272 federal regulations issued. The FRA regulations issued the Title 49 CFR Part 225 that are based on the Public Law 103-272. The former Accident Report Act is now Public Law 103-272, Chapter 209, Section 2901, 2902, and 2903 regulations. The following discussion of the requirements under the Part 225 pursuant to November 9th, 2010 miscellaneous amendment, accident incident final report. The final report activity July 1st, 2011. All right, 225. 5 definitions covered the data. Covered data of the reporting is intended to improve the FRA's gathering for the more accurate on the reporting, making the requirements to report these types of injuries more compatible with the occupational safety health administrative requirements. The inspector must be aware of some types of injuries categorized with the covered of the data have been inspected the FRA's properly when the insurers will not become the FRA's statistical publications. It will not count against the railroads. Consequently, the inspector will not find the record of the covered data every injury on the safety analysis webpage. They will find it on the contact in the Washington, D.C. Federal FRA headquarters office directly to obtain the information. 25.6 Consolidation Report. When the railroad are not permitted to consolidate with the reporting of the parent company communally controlled with the rail carriers, the railroad must first obtain the approval of the FRA. The section of 225.6 contains the instruction requesting approval requirements for notifying the FRA any of the changes in the document FRA 2062 and 6173 on the regulations of the government to ensure the railroad has obtained approval. In addition, with the checking of the railroad is properly obtained with the FRA with the FRA regarded to any changes. 225.9 telephone reporting of the certain accident incidents or other events immediately upon learning of an accident incident that results in any criteria specified in section 225N. Railroads are required to report the information to the FRA by telephone. The railroads must also be reported to the National Transportation Safety Board, but this will automatically have National Response Center notifies both agencies. 225.11 reporting accident incidents. Inspectors should ensure that all railroads of the territory understanding the required each of the railroads submit the FRA monthly report of the railroad. All railroad accidents include the monthlies in which they have any accidents. Inspectors can do the reviewing from the FRA Safety Analysis webpage to ensure the railroad and the territories have been submitted monthly reports to the FRA. The important also includes the freight train miles, passenger train miles, yard switch, and train miles, and the other important statistics. 225.12 Railroad equipment accident reports alleging employee human factor as a cause. Employee human factor attachment notice to the employee supplement. The railroad's responsibility regarding human factor causing accidents is cited in the statute 225.21, which states that files formal FRA F 6181 employee human factor attachment form that shall be used in the railroad to submit the railroad equipment accident incident report. The FRA F 618054 in reporting the railway equipment accident report. Accident incidents with attributed employee human factor. The form shall be completed in accordance with the instruction printed on the form. If occurring with the FRA guide with the preparing accident incident reports, the form shall be attached with the railway equipment accident incident report shall be submitted within 30 days after the expiration of the month in which this accident has occurred. Railroad employees' option regarding the human factor accidents is cited in the statute 225.21. Inspectors should ensure that the railroad provided with the employee the option filing the FRA 618078 when required. All right, 225.19 primary groups of accident incidents. Group 1, highway, railway, grade crossing, 61857, railway equipment, 61854, 78, 81, and 6180, F1, 618, 54, 618, 78, 818, 081, 618, 097. Group 2. Group 3, death and injury, occupational illness, F618055A, 618098, 6180-107. All right, the forms. The following list of the general purpose of each of the FRA forms listed in Statute 22521. F618098, illness or injury to the property. 618097, initial railway equipment accident incident record includes accountability incidents. 618078, sent employee regarding human factor accidents. 618081. 618081, employee human factors attachment. 618055, monthly report of summary of accident. 618055A, death of each of the accident injuries. 618054, accident report. 618056, annual railroad report of the employee hours of casualties. 618057, highway railway grade crossing. 6180-107, occupational illness. And 6180-1050, highway user injury inquiry form of the FRA. 6180-150 shall be sent every potentially injured highway user over the representative involved with the highway railway grade crossing accident incident. 225-33 internal control panels. The internal control panel included 11 required as stated by the statute. 225-33, which are summarized below. A policy statement that declares the commitment to complete with the accurate reporting, declares full compliance with the letter and spirit of the regulations, declares the railroad commitment to the principal harassment, intimidation of any person calculated, discouraged to prevent such a person from receiving proper medical treatment, from reporting such an accident, incident report, injury, illness will not be permitted to tolerated, will result in some kind of disciplinary action against employee, supervisor, manager, officer, railroad committing such harassment and intimidation. 2. The distribution of an above-mentioned policy statement to all employee, supervisor, personnel management, including the head places, procedures, processes, complaints, and other policy being violated to impose disciplinary action to violators. Whistleblowers protection must be also provided with the relevant procedure must be disclosed in all railroad employees, supervisor, managers, and officers. 3 copies of internal forms and description of the computer reporting system, the description of the internal procedures of the processing form, the computer data, the description of the internal review procedure reports and prepared for each of the department. 6. The description of internal procedures for collecting cost data. 7. The description of internal procedure for the ensuring communication among the railroad department's procedure for the updating information prior to the reporting the FRA procedure amending the FRA reports. 9. The name of the title of the reporting officer, including the frequency internal audits, the minimum of 1 per year, listing the location where the most recent audit report may be found in inspection photocopying. A description of the railroad organization, including identification of all the departments, regularity comes into the position, pertinent information of the title of each of the railroad reporting officer, a title of each of the department manager, all officers to whom the department of the managers are responsible. In the case of the form FR 6180-107, the alternative railroad design form, the statement with the name, the title, address, the custodian of these records, all supporting documents such as medical records and localization of documents, harassment and intimidation complaints as stated above pursuant to statute 225-33 A1, each of the railroad must adopt and comply with the ICP in containing with the policy statement declaring that it will not tolerate personal harassment, intimidation of any person that was calculated, discouraged, prevented from the person receiving proper medical treatment, reporting for his or her particular accident, incident, injury, or illness. Therefore, as part of the investigation, potential harassment, intimidation, the inspector should determine whether the railroad took out any disciplinary action against the employee, supervisor, manager, officer, railroad committing such harassment, intimidation, and what steps they took in response to any potential claim. The FRA's anti-harassment intimidation regulations prohibits only narrowly defined categories conducted in such an intended underdemean, interfering with the reporting of an accident, incident, illness pursuant to Part 225. Consequently, a railroad conduct does not relate to reporting requirements under Part 225. The FRA conduct can impose a civil penalty under 225. Accordance with narrowly defined parameters, the FRA enforces 225-33A with the respect to receiving proper medical treatment only to the extent of the proper medical treatment. After the effects of whether the injury or the illness will be reported, the FRA statute, the 225-33A1, only prohibits behavior intended to prevent discourage of the person from reporting his or her injury temporarily with or her before the injured person has formally reported his or her injury to the railroad. Therefore, a person receives medical treatment and the railroad does not attempt to dissuade him or her from reporting an accident, incident, injury, illness to the FRA. Therefore, there is no violation of statute 225-33A1. Note, a violation may exist if the railroad attempts to make the employee return to work earlier with the intention of the avoid reporting additional days of restricted duty in the days away from the work. Consequently, any complaint memo must be addressed in 2 items. Did the action prevent delay from the injured person from receiving proper medical treatment? Did anyone manipulate the situation to change or prevent the reporting of it? It is extremely important to each operational practice inspector address both these issues when investigating a complaint writing of the memo regarding harassment and intimidation. The inspector must clearly state the memo whether either the issue exists or neither issue exists. Note, any employee whistleblower refers under the statute 20109 enforces the OSHA in accordance with the procedures set forth in Title 29 CFR Part 1982. When the investigation of harassment complaint, evaluate the situation contemporaneously while before reporting the injury to the railroad. Look for a flagrant, egregious language in medical and a medical card intended with the influence change of the physician judgment, telling and implying no investigation or discipline if the injury is not reported, or conversely that there will be investigations or disciplines if reported. Investigations of the complaint and looking for any of the request samples of prescription rather than the actual prescription flagrant causes the conflicting medical opinions of managers interfering with the employee's ability to prompt and jury report, then disciplining with the employee for the failing to report the promptly, requesting an employee to wait until the next day of the medical treatment, managing insisting that they would be allowed in the examination room. Managers insisting that they be allowed in the examination room. When it's not considered intimidation or harassment, acts occurred before January 1st, 1997. Anything that is not linked to the railroad safety prohibited employees are talking to the FELA lawyers or about accident injuries. Notice of the interpretation. On March 30th, 2009, the FRA issued the Notice of Interpretation of 74-1409-1-14092 and informed the interest party of the application enforcement of the harassment intimidation provisions contained in Title 49 CFR Part 225, specifically relating to the situation in supervisor or other related official companies that are injured and employed into the examination room. The notice of the interpretation gives the guidelines that will help inform the regulated community to identify when such behavior constitute harassment or intimidation calculated with the discourage to prevent reporting of an accident, incident, injuries, or illness as a result of the supervisors are also allowed in a treatment room with an employee in a limited circumstance. Supervisors are generally prohibited during the treatment room as potential to interfere with the employee's ability to receive the proper treatment. All right, HIPAA's laws. Health Insurance Portability Accountability Act. The FRA inspector should have regional managers contact with the FRA chief of the townsville if they are refused to access medical records. Consequently, the inspector may need to contact the railroad and discuss any issue of the Health Insurance Portable Accountability Act ahead of the inspector's arrival of the railroad property. Ask for sensitive medical records. If the inspector expects a problem, he or she can contact the chief counsel, the Part 225 inspector, and perhaps the subpoena available. HIPAA question and answers. Is the FRA authorized by law to carry out public health activities? Yes, by delegation of the Secretary of Transportation. The FRA is authorized to statute to carry out the investigation, including issuances of subpoenas to require the production of documented records. Question 2, the FRA subject to the HIPAA. Answer, no, HIPAA only applies to the covered entities. The FRA is not covered in the entity. Consequently, information obtained by the FRA is no longer afforded protection under the HIPAA. The FRA should, however, use the discretion when redisclosing any private health information, so do so only legitimate government purposes. Question 3, is a subpoena necessary? No, however, the railroad covered entities may request a subpoena before they release the private health information to merely protect themselves from liability. It does not necessarily mean that they are being uncooperative. Costs and reportable damages. If this includes the labor costs and other costs of the repair, the replace, in kind with the damage of the track and the signals, the track structures, roadbed. Reportable damages do not include cost of clearing of the wreck. However, the additional damages to avoid above listed below while clearing the wreck is to be included with the damage estimate. Estimates of the issue included with the reported damage. 1, rental of the operation machinery such as crane, bulldozers, including service or contracted to replace, repair the track of the right of way, the associated structures. 2, the cost associated with the repair or replacement with the roller bearings on or units whether derailed or submerged in water. Replacement costs included labor costs resulting in wheel set change out. Alright, equipment damage. It includes all costs, included labor, material associated with the repair and placement, and kind of the on track of the railway equipment, tracks, trailers containing the flat cars considered to be landing, and damage. These are not to be included on the track equipment damage. Damage to the flat car carrying the trailer container is to be included with reportable damage. When a track equipment is damaged beyond the repair, the total reproduction cost of the equipment includes the betterments of 10 added additions is to be calculated in accordance with Rule 107 of the current edition of the Field Manual Association of American Railroads Interchange Rules. The total reproduction cost is dissipated with the field, reflecting the amount of the usage of the equipment to be has been subject. The depreciation percentage will be determined by 3% annually, the maximum of 30 years. The equipment over 30 years over the value of 10% of the total reproduction cost. And the replacement kind of the cost is equipment damage beyond the repair as a result of the calculation. Track damage. All costs, including labor and material associated with the repair replacement of the kind of the signals, tracks, and track structure, including bridges or tunnel roadbeds that were damaged in the collision, derailment, or the reportable event. When the track signal structures are damaged beyond the repair, the current cost of the new materials to be used. However, the replacement second-hand and the second-hand rail will be charged with the current cost of such a rail. When estimating damage, the labor cost will be reported only with the direct labor cost of the railroad, e.g., hourly transportation costs, hotel expenses of the car. Fringe benefits excluded with the calculating direct labor costs, overhead with the excluded with the calculating damage costs, and acceptable non-uniform treatment overhead with under the current process. For services performed by the contractor, the directly hourly labor costs are calculated with multiplying the contractor total labor hours exchange with the railroad ability, the directly hourly wage rate for the railroad worker in the particular craft. However, the railroad cannot match the equivalent craft for the labor hours spent with the contractor. The railroad might use the load rate if the cost had be by hours of labor, fringe benefits, and other cost fees for the service charged by the contractor for the tasks associated with the repair track of the equipment and structures due to the train accident. Collision definitions. Head-on collision. A collision in which the train or locomotive is involved with the trailing of an opposite direction on the same track. Rear-end collision. A collision with the train or locomotive is involved with the traveling in the same direction on the same track. Side collision. A collision of the turnout where one consists of the strikes at side of another. Consisting raking collision. A collision between the landing of a consisting adjacent track with a structure such as a bridge. Broken train collision. A collision where the moving train breaks into parts and impacts occurs among these parts when the portion of the broken train collides with another consists. Railroad crossing collision. A collision between on-track railroad equipment at the point where the track intersects. Chapter 12, Pending. Hours of service, railroad employees, record hour requirements, and Chapter 211, United States Code.